Hello, everyone. My name is Hasan Sorrells, and this is the Leadership Lessons from the Great Books podcast, episode number 67, with our returning guest, who was here in our last episode, or our most recent episode that we had with Libby Unger, where we discussed the Constitution, the Federalist Papers, and we touched a little bit on the Anti-Federalist Papers, and some recent Supreme Court decisions. Our, as I mentioned before, old friend of the show, Dorollo Nixon Jr. Esquire. How you doing, Dorollo?
Doing great. How are you, Hasan?
Great. So Dorollo's camera is working today, which is great. So we will have video. We will be able to see his glorious face. And as you can see on the video, you may not be able to hear this on the audio. Actually, you can't hear this on the audio. But this is going to be the two black guys breaking things down. But because this is a book podcast, I am going to open up with a quote from the Anti-Federalist Papers, the same quote that I used last year when we started talking about the Anti-Federalist Papers. And you can go check that out. I believe it was episode either 26 or 27. So I'm going to open up from Benjamin Franklin's speech in the convention on September 17th, 1787, the Constitutional Convention in Philadelphia. And I quote, "I agree to this Constitution with all its faults, if there are such, because I think a general government necessary for us, and there is no form of government but what may be a blessing to the people, if well administered. And I believe farther that this is likely to be well administered for a course of years, and can only end in despotism as other forms have done before it, when the people shall become so corrupted as to need despotic government, being incapable of any other. I doubt, too, whether any other convention we can obtain may be able to make a better constitution, for when you assemble a number of men to have the advantage of their joint wisdom, you inevitably assemble with those men all their prejudices, their passions, their errors of opinion, their local interests, and their selfish views. From such an assembly, can a perfect production be expected? It therefore astonishes me, sir, to find this system approaching so near to perfection as it does. And I think it will astonish our enemies, who are waiting with confidence to hear that our counsels are confounded, like those of the builders of Babel, and that our states are on the point of separation, only to meet hereafter for the purpose of cutting one another's throats. Thus, I consent, sir, to this Constitution, because I expect no better, and because I am not sure that it is not the best. In order to form a more perfect union." These are the words of men, leaders, all with their own foibles, passions, blind spots, and talents, who sought to bring to bear their knowledge and wisdom to the toughest organizational challenge any leader can ever face, that of creating a new country. And I mentioned this last year. In our time, in the year of our Lord, 2023, or whatever year of our Lord you happen to be listening to this in the future, more countries have appeared on the global horizon than ever before. Since the collapse of Western colonialism and the end of the scourge of Marxism and a multi-country geopolitical scale. And now we are used to reading or hearing the news about one new country or another. And by the way, I do believe we will continue to hear that news on into perpetuity. And yes, those countries fall into disrepair, disunion, and despotism because of the venal, corrupt character of their leaders. More so even, or followed on from, the venal, corrupt character of their peoples. Fundamental to any creation of any organization is the ability to disagree with the majority opinion, and even Dorollo has said this, and to be allowed the freedom to retain life, limb, and property. This is not an obvious conclusion for human beings to run to, again, as Dorollo has mentioned before on our podcast, as in the history of the world. What we mostly see is that disagreement with the majority tends to lead to the minority suffering evils, or as the Greeks would say, and as I have repeated very often on this podcast, the strong do what they will, and the weak the weak suffer what they must. And yet, even in our time in the United States, even in our blinkered era, and I think Benjamin Franklin would look upon our era and say that we have fallen into corruption, but your mileage may vary on your opinion on that. In our blinkered era, in our blinkered time, that is not yet still what happens here. Even with all the cultural machinations and the technological innovations of the last, 20, 30, 40 years, we haven't still been able to shake the idea that disagreeing with someone doesn't mean you physically destroy them. Although I would argue that in 2020, we kind of tottered on the edge of discarding that idea. And that's why we do this podcast, because we have to have agreements, but we also have to have disagreements. We have to have the ability to disagree underneath our system, the freedom to associate and the freedom to speak, and also the freedom to just say, I think you just got it wrong, and to still be able to go and have a barbecue. Or if not a barbecue, go back to my own house and be left the hell alone. And that ability is something worth fighting to preserve. And so, back from a short siesta, or maybe back from a long siesta, in the blistering triple-digit hot sun in the high desert of Arizona, somewhere deep in a bunker in an undisclosed location, we would like to welcome back for the final time this month until he comes back next year, the good friend of the podcast, Dorollo Nixon. Hello, Dorollo. How you doing?
Great. How you doing?
So we're going to jump right into it because we were going to originally discuss the Federalist Papers and the Anti-Federalist Papers, but there were some things that were brought up in our last episode that we had with Libby Unger, some topic areas that I wouldn't say we gave short shrift to them. I wouldn't agree with that assessment. I think we covered them as well as we could in a panel type discussion where everybody had to go back and forth. And I think we covered them quite well, and we laid down some ideas and we introduced some ideas that I'd like to explore a little bit more in depth with you, and potentially with Libby on another episode as well. Well, let's start off with this idea, and we kind of addressed it a little bit, like I said in that podcast that we did with Libby. We discussed the most recent Supreme Court decisions around the website that was the state of Colorado said to the website designer that they had to design a website for a same-sex couple, and that went all the way to the Supreme Court, and the state of Colorado lost that case in front of the Supreme Court recently, as of July of 2023. And in losing this case, this was the second bite at the apple that the state of Colorado had taken on going to the federal courts, going to the highest court in the land, and getting smacked around. The first case was with the baker, the infamous baker, who would not bake a cake for a wedding between two individuals of the same sex. Both of these decisions fundamentally go to, I believe, how we think about free speech and how we think about free association. You and I have discussed this a little bit off mic, and I'd like you to bring some of your ideas to the public on this one. You take a little bit of a different tact on this. You think this is about freedom of religion. Could you explain to the folks why you believe that both these decisions are about freedom of religion? And then I'll jump in with my association piece there. Let's start off with that.
Sure. So certainly the wedding cake case, right, which of course has not been the first one of these, but anyway, my understanding is that I'm going to call him the vendor's objection to providing services that he normally can be contracted for and provide is only in a narrow context where the particular circumstance for which his services are sought happens to be religious. Okay. One of the most popular and widespread religious ceremonies, irrespective of religion, happens to be a marriage ceremony, which we call a wedding. And so providing food for that, frankly, providing food for a religious ceremony in certain contexts is just straight up worship. And so I have, lived all over the world, traveled all over the world, and have participated either viewing or being, seated down at various ceremonies of one type or another, not always Christian. If I'm not mistaken, certainly Christian, Jewish, Buddhist, and Hindu. I think also Muslim. I'm just trying to, like, my brain is searching for the example that fits that. But basically, in certain of the ceremonies and certain of the religions, bringing food itself is literally an act of devotion. Right. And so when somebody in America, irrespective of their particular religion, is seeking food for a marriage ceremony or to celebrate a marriage ceremony, it's obviously, in my view, it's patently religious behavior. Now, the First Amendment, as you know, protects the rights of American citizens to engage in the religion of their choice, and prohibits to put it slightly more narrowly, it prohibits state action in contravention to someone acting out his or her religious beliefs, is basically what it does. Excuse me. And so where we have a religious context, where we have religious actions, that amendment, has a clause that, a direct reference to freedom of religion. And so in my view, because you have both, that's the strongest protection. Now, in the free speech context, and I know this as a constitutional lawyer, in the free speech context, freedom of religion per se, or claims grounded in freedom of religion rather than in speech or association, it's, gone by the wayside almost. Okay, rarely does one see, even, you have to go back basically some decades before, and it may be actually longer than that, before you're seeing a good, strong, freedom of religion claim, rather than, my free speech rights are being denied. Okay, but what first, is it speech or is it conduct? And then regardless, is the particular set of words or the particular set of acts, are they actually religious? Because the answer is yes, there's a better protection in my view. There's a more natural and logical and rational nexus with that part of the First Amendment rather than trying to ground it in one of the other aspects to it. And so, from my perspective, that's what I see, where I see, oh, okay, I understand the man's objection. I think he's entitled to that. And I certainly don't think that the state, any state he lives in, is entitled to either pull his license or shut him down, because he doesn't want to participate in the devotion in a ceremony where arguably either he doesn't share that religious belief or it conflicts with his own. I don't believe that's too much to ask in America at any point, certainly not in 2023. The jumble and hurly-burly exchange, vociferous exchange of opinions, ideas, those interactions, those are among the things fundamentally that make America great. And with our competitor nations, to frame it that way, one of the things you see, unfortunately for them, is that they usually don't do that as well. Okay. And here I'm not talking about capacity as much as I'm talking about an intent to say, I'm going to let my neighbors think and act the way they wish, rather than seek to impose upon my neighbors my own framework for speech or action in a certain context. And I just think that, we're willing to do that. And in other nations, they're just not and I mean other free nations. Obviously, I'm not talking about a place like Syria where that's not going to work, because you're just going to get killed. Okay, fine. I'm not talking about that. I'm talking about, let me give a concrete example. So in the UK, you can make certain statements about somebody else's religion or what have you and get prosecuted. I don't understand why they're calling themselves a free country. Like, I don't get it.
Right.
And I certainly don't get it where to contextualize it. I don't hear about people getting prosecuted for talking about the Lord Jesus Christ. I hear people getting prosecuted for stuff they said about, for example, Muhammad. So one of the issues I have with that is, even if I decontextualize it from the UK's Christian history and heritage, even if I do that, which I'm willing to do for the sake of the argument, even if I do that, the thing that gets my attention is if I then put a pin there and go to the parts of Asia where Islam is in the predominance, right? One of the struggles there in terms of civil and individual rights, it's the removal of blasphemy laws. And so this is a struggle going on there right now, at the same time that the UK seems to be going backwards and saying we're going to enshrine protections here. So somebody here practicing a religion that didn't originate here or that hasn't been practiced here on that island, the island of Great Britain, say, for, more than a couple hundred years max. I mean, there's an interruption, and there's, what Queen Elizabeth I did with her expulsions of Moors, and I'm just leaving that as a lacuna. Okay, so effectively, for 200 years max, you may have had Muslim practice in the UK. Okay, so for the UK government to take that big and bold of a step on a certain level is admirable. What gets my attention is wait, stop. First, you got free speech, then you got freedom of religion. Okay, great. But have you looked over here where people are fighting to get rid of blasphemy laws because they value that type of civil exchange and they value the freedom and the protection from government overreach? Why are you guys moving in the opposite direction? Right. I find it fascinating. And I find it disturbing also. It's a country I love. I had the privilege of living there. I've studied their laws in their own schools and school one. And then, it's a country whose culture I follow and whose laws and, parliamentary acts I pay attention to. So it's disconcerting for me where I see that. I'm like, oh, okay. Really? You're going to send someone to jail because of words that he or she said? Wow. Because our notions of free speech here in North America came from over there. Because that wasn't happening, for example, in France at all.
Right. And the challenge of the UK has always been things are codified in common law, but they are not codified in any sort of founding document which goes beyond common law. And so you get that that malleability, because what you have is the common law going along with the common culture, which, interestingly enough, when you look at this most recent case in front of the Supreme Court, the minority dissent that was written by Justice Sonia Sotomayor was one that focused on the strides that LGBTQ people have made in our country in the civil structure. And her dissent stated that the court was in essence putting those strides back. She was making an appeal to common law versus an appeal to a founding document. And Gorsuch, who wrote the majority opinion, even stated that the minority on the court seemed to not be reading the same case, seemed to not even be seeing the same issue, right? And this is where, in looking at our founding, I'm quite grateful we're not in a parliamentary system based on common law. Because in a parliamentary system based on common law, when human passions, I believe this is something Benjamin Franklin would say, as would the rest of the founding fathers, when human passions shift, as they are sure to do, then we're off to the races in another direction. And thus you wind up in a place where, even though we have a principle of free speech, but it's not codified anywhere, the second the culture turns and says this thing is blasphemy, but this thing isn't, and by the way, it can shift on a dime tomorrow, now all of a sudden you're putting people in jail for violating people's feelings because their feelings got hurt.
Correct.
And this is something that we see again reflected in America. And so you saw this also reflected in the affirmative action case, which we're going to get into in just a second. But you had minority dissents, and I don't know if I think I sent you the Supreme Court decision on the affirmative action case, the most recent one. But when you read the minority dissent, either from Sonia Sotomayor in the case of the website designer, or from Justice Ketanji Brown Jackson in the minority dissent on the affirmative action case, it is almost as if the minority is living at a totally completely different reality. How do you maintain the ability to talk to somebody if they're not even viewing reality in the same way as you are through a legal lens? Forget through a cultural lens, common culture, okay, whatever, but through a legal lens, like even the legal appears. So like in Ketanji Brown Jackson's dissent, she literally dismissed all of Clarence Thomas's concerns as if they were irrelevant. She literally put them in a footnote. Her entire dismissal is in a footnote, which of course is a dig at him. It's a dig by the current generation of Black radicals in our country at the past generation of individuals they thought were too accommodating. So that's a racial dig, but it's also a dig because Ms. Jackson as well as Ms. Sotomayor cannot be convicted because they've earned their degrees. So how do we navigate a court where this is the case now? Because what we're doing is we're pushing up things, cultural issues up the hierarchy. And we talked a little bit about this with Libby, and you mentioned this a little bit with Libby. We're pushing cultural issues up the hierarchy to be decided in the highest court of the land that probably should be just worked out in culture, because minorities don't. The most common appeal by a minority group is to the electorate, which is to say to the Congress, not to the law. And when those
wait, sorry, where is this?
Where is what?
So what I noticed about the US is we lead the world in terms of the use of the judicial system. Okay, this is how strong we have rule of law in our country. The judiciary is well used to advance people's claims about their rights.
Well, it's well used to advance people's claims about their culture, which may be said, or we may conflate with rights, but you see this in both the website design decision, in the minority dissent, and in the affirmative action dissent. You see both of them are claims about culture rather than rights.
Yeah, but I mean, I was starting circa 1948, in Shelley's case. Shelley's case established that the otherwise valid contractual device of a racially restrictive covenant was no longer enforceable in the United States. And the reason was because a white World War II veteran wanted to sell a house to a Black World War II veteran whom he knew. And there was one of these covenants as part of the deed. And so the sale couldn't go through or couldn't be recorded. And here the detail, whichever it was, doesn't matter. They sued to challenge and they won. It's called Shelley's case. It was the first case we learned about in property class, and I never forgot. But from Shelley, so that was a question where the two men were claiming, no, this is my property. I have the right to sell to whomever I wish, who can
Right.
pay the money that I'm saying. Here's my friend. He can pay the money. I don't care what device somebody put in there to prevent somebody who looks like him or fits into his category from being able to purchase it, who otherwise has no disability, to prevent purchase. And that just refers to money. And so they were able to establish the right to sell your house to whomever you wish, irrespective of those covenants, which for the record didn't disappear. I did real estate conveyances in New York from 2012 to 2020, and I saw some of them in transactions I was doing. They were still there. And so they have been enforceable since 1948, thank God. Anyway, that jumping to, Brown versus Board of Education of Topeka, Kansas, the notion that in receiving state services, and this of course is a reference to, the 14th Amendment, which is what we were talking about last time,
Right.
that, equal protection of the laws meant something such that to provide what we're going to call standard services at one type of school, but substandard services at another type of school, because the second school happens to be populated by people who look like you and I, that didn't meet constitutional muster. And so, but the chain of cases goes on. And so I think, that the use of the judiciary to advance people's rights is not just fundamental with how our system works, but where it works better here than, say, Australia or the UK or what have you, where you can similarly sue over, the violation of your rights in certain contexts. But we have a culture with small c. In America, we have a culture where, you can go to court. I mean, when you and I grew up, they had, that amazing TV show, The People's Court, with Judge Wapner. Exactly.
Wapner at 4. I'm gonna watch Wapner at 4.
But Judge Wapner, he's presiding over these, small claims actions. So there's a limit in terms of the amount of money damages, but basically you're listening to people air their dirty laundry. But in a court, this is not Jerry Springer. That was the next decade. Okay. This is a court of law. And if you read the fine print, which, I did at some point, either as a lawyer or beforehand, it almost functioned like an arbitration in that the two parties had to agree to submit their dispute to this court. Okay.
Right.
And so that effectively makes it like an arbitration, but anyway, and binding arbitration. And so then they go through this process and, they air out their grievances and then have somebody apply. And in my view, it was more legal principles than actual law. That's one of the differences between what was going on there and, say, a case in an actual small claims court in place X. What the law said, I don't recall often being voiced. It was more normative in the sense of, okay, well, what did you guys contract to do? Did you fulfill your obligations? Rather than, well, what does the law say about this type of contract? What does the law say about contract itself? In the contractual disputes where I'm hired to litigate, those are issues that come up. And other, procedural things like, oh, all of what you're saying can be true, but I see the statute of limitations is run.
But what we've done in the United States, and I'm glad you brought up the People's Court. I'm glad you brought up Judge Wapner. I would bring up Judge Judy, which was,
the next decade.
The next decade. Yeah, exactly. Yeah. Judge Brown, who was somebody, and then of course Jerry Springer, and Oprah Winfrey, and the talk show madness begins. I think what you're seeing there, and we talked about this again on the other podcast, and I want to revisit this a little bit because I think this was a good point that you made, is we're seeing the expanding of the franchise. So we're seeing the expanding of the franchise of things that we consider to be rights, moving away from a negative direction, which is what's defined by the Constitution. We've mentioned this on the podcast before, and moving into a more positive direction. Negative direction, what government cannot do to you, right? What government cannot take away from you. Positive direction, what government can do for you. Franklin and the founding fathers would define that as despotism. They would define the expansion of such a franchise towards positive rights as being a fundamentally despotic act. And they would look at the clogging of the court system as for the expansion of these positive rights as a negative use of the court system, a negative use of the judiciary. How do we square that circle? Because this is the fundamental thing. Like, we at one time I saw a statistic somewhere that we actually make more lawyers at one time in the United States. We made more lawyers than there were laws on the books. That's insane to me. As a lawyer, that should be insane to you.
I'll take it though.
Yes. Well, it is self-serving at the end of the day. It does help.
But not just that. But yes, it does. It does.
But how do we push things down the hierarchy so that they are resolved between people rather than raised up? Because it seems as the franchise expands. Now, again, we're going into LGBTQ, right? And whatever may come after that. The next step after that is going to be transhumanism. It just is. Like, transhuman rights are going to be the next thing. And that's going to be another more water in the pool of expanding rights. As cybernetics become more and more popular and become more and more online, you're going to see, again, an expansion of a call, expansion of the franchise, an expansion of a call for positive rights for people who identify themselves as being merged with a computer or merged with some sort of electronic device. The tension between the reduction of the franchise or the reducing of the franchise, the expansion of the franchise, shouldn't that just all be worked out in culture? Because I think this is fundamentally a politically conservative argument. And this is what, by the way, conservatives would argue for, or if we were to put it in a modern terms, old school liberals would argue for. Not progressives, but liberals, right? And so are we just using the courts for too much at the end of the day? Why can't we just work these things out in culture? I think this is the thing that frustrates most regular people. I really do, because they look at something like a cake baker or a website designer, and here's the first thing an average person says. The average person looks at that and goes, if you want to marry another dude, I'm fine with that. Just go find another bakery.
Well, let me play.
And then they throw up their hands. Right. And then they throw up their hands.
But let me play. I won't say devil's advocate, because I'm not trying to be pejorative to one side in this discussion. But I would tweak it and say, at least the average person I'm used to talking to will say, oh, okay, I don't really care about whom you're marrying, but dude, it's just a cake. Like, what's the problem? And so my concern is, the trend I've noticed, and I mean, I don't even know if it shouldn't qualify as a statistic. And so I'll put it this way. In my opinion, the percentage of Americans for whom that would be their gut level response has been increasing over the last 2 to 3 decades. I think that's an opinion that would be supportable by statistics, but I don't have them, so I don't want to call it a statistic. Okay. So that, against the background of that trend, what gets my attention is, what that person is voicing is actually their own normative framework in which a cake is just food. And as I said towards the beginning of this podcast, a cake baked in preparation and then offered, even if it's for sale, but offered as part of either a marriage or in celebration of a marriage, that is devotional in a religious sense. And so against the background of that rising opinion, or against the background of, in my view, the increase in the popularity of that opinion, And at the same time, if we want to throw in something that's actually statistical, you can track the decrease in religious practice. We then have, people objecting to, or even worse, what you were talking about before, not even understanding the normative frame of reference in which a cake is not just a cake. And that does, as you, I think, pointed out, well, that doesn't bode well for our society. And this may be happening, as you indicated, at the highest levels, where these are well educated. I mean, the judges basically went to 2 schools.
Well, but okay, so that's where my association assertion, my argument from a freedom of association then becomes more important, or becomes more salient to an overall culture where the franchise of rights is expanding. I don't want to associate with you, and I don't think you have a right to my business. And just because I started this business, look, everybody knows in the market economy, I'll flip it on its head. Everyone knows that when an entrepreneur takes a risk and goes into the economy and puts something in the market, the market has a right to reject that entrepreneur. You're not owed the business you want. That's one of the first things that an entrepreneur has to learn, right? You may want people walking into your cake shop and buying, camera shaped cakes. But if the market wants, tractor shaped cakes, because that's the only thing that's popping into my head right now, guess what you're going to make? You're going to make tractor shaped cakes, or you're going to go out of business, or here's your third option. You're going to make camera shaped cakes, but you're not going to have as much business as you wanted. Those are your 3 options. Everybody sort of acknowledges that in a market economy, a free market economy, the market has a right to dictate to the entrepreneur what the success level is that the entrepreneur is going to have. We all agree with that. We're all fine with that. If we weren't, market wouldn't work. Okay. The public, or the reality, though, is that the entrepreneur also has a right to dictate to the market about what he or she will put out there. That's freedom of association. That's fundamental to doing business. I am not obliged to do business with every customer that walks in my door. I'm just not. I don't have to associate with you. And by the way, the most basic kind of association that I think goes past religion is money. My money I don't have a right to take the money out of your pocket. We all agree with that. That's theft. But I also don't have the right to you don't have the right to put the money in my pocket. There has to be an even exchange here, right, of goods and services. There has to be an even understanding. That's why you have signs on stores that say we reserve the right to refuse service to anyone. You see these signs all over the place. Why do you see these signs? Because if I don't like you, you can get the hell out of my store. That goes beyond religion. That goes to association. And so that's where I think an association argument is much more powerful than even a worship argument. And I get it that both the association argument and the speech argument both come out of a religious context. But if that religious context is cut off by virtue of a generational J curve going up and to the right, where less people are religious or even have an understanding of religion than before, then we're going to have to make different arguments. And I think the association argument is probably the best one, which gets us to another area, which I wanted to revisit from last year's podcast. And this is the issue of reparations. So California's Reparations Task Force, this is according to NPR's most recent story on this that was released on July 21st of 2023. It was an 8-minute little story that they did. And so I'm referencing that in case you want to go Google that, you can. California's Reparations Task Force has issued its final recommendations for a state reparations program for the descendants of slaves. State lawmakers must now decide whether to adopt any of them. The article, well, it's not really an article, it's a transcript of an interview that was done with a couple of folks that were on the Reparations Task Force, including the head of the California Reparations Task Force that came out of the California legislature. And, the Reparations Task Force, this is according to one of the people interviewed, has recommended cash payments, in some cases hundreds of thousands of dollars or more, for any Californian who can show they are the direct descendant of a Black enslaved person or a free Black person alive before the 20th century. The report also recommends tax breaks, free tuition, help with healthcare, and other programs designed to help African Americans overcome the systemic racism that is slavery's legacy. Monica Montgomery Stepp, a San Diego City Councilwoman, also on the task force, said the time for all of this is now, which is, of course, what every revolutionary says.
Correct.
Correct. If I'm an individual in California, if I'm a business in California, my answer is no. And then I shut down my business and I leave. No, you don't have a right to take my money and give it in reparations to some. No, you just don't.
Well, I mean, the mechanism to do so is straightforward. It's just a tax.
Okay, so just like you're right, just like any other tax, then I refuse to be taxed underneath your system. You have a good day.
Right. And you then get a bill that follows you in the mail. But yes, do I think that it will accelerate the exodus of free citizens from California? It might. I think there's a much easier route, though, for lovers of California who have zero intention of, getting on board with an obvious, socialist scheme like that, which would just be, as we were talking about, sue. Rather than have the discussion, just sue the state of California and say, well, this is not constitutional. And what fascinates me is, in preparation for our last talk, I was looking at different portions of the 14th Amendment. And then I saw Section 4, and then I couldn't believe what I was reading.
Hold on a second now. Before we go much further, I want to go ahead and pull up the 14th Amendment in the U.S. Constitution. I want to go ahead and pull that up. And I know that we read it in the last podcast. But for those of you who have not listened to that, I'm going to go ahead and pull this up. And let's see, here we go. Article 14. All right. And which section was it that astonished you?
Section 4.
Section 4. So Article 14, Section 4, the validity of public debt, right?
Yes.
Yes.
Now, I'm going to make a reference to the first section, but Section 4 is the one that got my attention.
Okay.
Quickly.
So let's jump into the Constitution before we jump into what is catching Dorollo's attention here. So just to refresh, Article 14, I'm sorry, not Article 14. Yes, Article 14 or Amendment 14, sorry. Section 1 of the U.S. Constitution, and I quote, all persons born or naturalized in the United States are subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That's Section 1. That's the Equal Protection Clause. Section 4, skipping sections 2 and 3 for the time being. Section 4, the validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave.
Keep going.
But all such debts, obligations, and claims shall be held illegal and void.
Period, close quote.
Period, close quote. Go ahead. I started laughing, but you go ahead. You explain to the folks why I started laughing.
So one of the first ironies is just how I found it. It was like a fold in a page. And so the language started at the top. And so my eyes went to it. And then all of a sudden I started focusing. I said, wait a minute, what? And I read it and I was shocked because I know I've read this before. I'm certain I've had to study it before, certainly in law school, if not afterwards. I didn't remember that clause. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or, which of course means, or we're going to add something else that, you know, that is a predicate to the same subject, any claim for the loss or emancipation of any slave, semicolon, but all such debts, obligations, and claims shall be held illegal and void, period. Close quote. It's to me, what gets my attention is there is in the Constitution itself, there is a reference to payments related to slavery, and payments related to slavery in the context of, frankly, the next amendment, which, the previous amendment, the 13th, which banned slavery. Great. So slavery is banned. Next, we're going to ban all such debts, obligations, and claims that relate to loss or emancipation of any slave. Now, there is both a natural and a logical and an assumed direction in which this language is marshaling things, which, you know, frankly is, well, the opposite of that is what happened in the UK, right? What I see is like one of my several great grandfathers, slave owner, saying, "You're liberating these people, pay me. You just took my property, you got to pay me, you know, where's my just compensation?" And it's in the Constitution that that man would have had no claim, right? But here, what gets my attention is not that. I get the context. It's the use of the words any, or, any, again, any, and all such, meaning, wait. So any debt or obligation, like the obligation to pay reparations, any state, like the state of California, okay, what is the debt or obligation related to? Is it not about, and
Well,
it's any claim for loss or emancipation.
Let me push back. The debt or obligation is to make remedies not for slavery, as was defined in the 14th Amendment. The debt or obligation is a remedy for systemic racial discrimination, which is not, by the way, mentioned explicitly anywhere in Section 4 of the 14th Amendment.
Correct. But what we have in Section 1, of course, is the reference to all persons.
Mm-hmm.
And not just that. But say again.
There you
Is that better?
Yeah.
Okay, cool. Sorry. Yeah. The all persons language of Section 1 is all embracing, and you know, it to me settles permanently any questions of whom is being franchised, at least at this point, whom is being franchised, you know, in the United States. It's there.
Well, let me talk about eligibility for reparations as was defined by the California Reparations Task Force. This is according to the Los Angeles Times on June 29th, 2023. They published an article, and it lays out the eligibility for reparations according to the California Reparations Task Force. Okay. The task force voted to recommend, quote, only those individuals who are able to demonstrate that they are the descendant of either an enslaved African American in the United States or a free African living in the United States prior to 1900 be eligible for monetary reparations.
Mm-hmm.
Okay. Number 2, second bullet point. In its compensation models, the task force cited population estimates from 2020 of less than 2 million non-Hispanic African American residents who lived in the state. Okay, bullet point 3. The task force recommended that the legislature create a new Californian African American Freedman Affairs Agency dedicated to implementing the task force recommendations and ensuring state agencies properly carry out any policies adopted into law. Among those duties would be helping people determine their eligibility, The agency should have a, quote, genealogy branch, and this will touch on something that you are very passionate about, genealogy branch to support potential reparations claimants by providing access to expert genealogical research to confirm reparations eligibility, according to the final report. Compensation, the pay model suggested. Compensation for health disparities. Compensation for mass incarceration and over-policing of African Americans. Compensation for housing discrimination, get this, between 1933 and 1977. Additional compensation for unjust property takings by eminent domain and the devaluation of African American businesses. And the task force recommends that the legislature provide initial down payments to begin the process, with more payments to follow, and prioritize the elderly as the first in line for compensation. None of this, from the point of view of a progressive justice, let me put on my Sonia Sotomayor cap here, sounds like it has anything to do with anything in the 14th Amendment. Matter of fact, it sounds as though the California Reparations Task Force has done an admirable job of seeking to redress systemic issues in the 20th century, which abrogates any 14th Amendment Section 4 or Section 1 argument you may bring to the court, Barrister Nixon. Your case is not going to be heard. You will have a good day.
Well, I think they would hear it. It's too important to, I think, to sweep under the rug. They might not agree, but if I'm in California, you then sue, and then you're hoping that the federal district court, whichever one you choose, probably one in or around San Francisco.
It's going to be the 9th District Court.
But anyway, we'll grant an injunction, right?
Right.
And then you don't have to worry about enforceability until it's resolved. But yes, yeah. So it's interesting to me because unfortunately, that's often how legislation works. It's an omnibus. There's all this stuff thrown in there.
Right.
Some of that actually sounds perfectly fine to me, and frankly may even be overdue. I'll give you a really, really narrow example. Okay, the unjust use of eminent domain to take Black people's houses. Oh, okay. If that was actually an issue and you're willing to come forward with evidence, the state who did the takings is willing to admit, yeah, so the guy running that program for these 10 years was a Klansman, and he was on record saying that he was basically going to try to get as many Black people's houses as they could get. If that's the case, California needs to compensate these people, period. There's no question in my mind at all. But that's not, of course, the main part of this bill. And it's not how it's marketed, right? Because that's all this is marketing, right? And it's also not the real moral root. The real moral root is trying to establish a cash payment for descendants of slaves to compensate for basically decades or centuries of free labor. So, yeah. Now I think so I can see justice in doing that. I don't. My views changed on that subject when the result is still the same, but my views changed on the subject when I discovered that the United Kingdom, or I guess to be most accurate, His Majesty's Treasury, which of course that just switched, right? It used to be Her Majesty's Treasury from 1952 until she passed away. Then it was His Majesty's Treasury going back, and then it was Her Majesty's Treasury, Queen Victoria. And then when this started in 1833, it was His Majesty's Treasury again. So regardless of if it's his or hers, the Treasury of the United Kingdom had been compensating slave owners and their descendants for loss of property into the century in which we are in, and at least towards the end of the last decade. And when I learned that to me was a light bulb moment where I said, oh, so this is actually possible. You could actually figure out, well, whom has a legitimate claim, has them apply for, membership, as it were, to a fund, and then you could compensate them. But of course, the United Kingdom is a kingdom and not a republic, okay? And so my issues with this are that I think this would be detrimental to the American republic. And I will give you the language of a far more eminent jurist, far more eminent lawyer, and certainly an eminent jurist, and some of the words that ring true through today, and also help shine a light on where the U.S. government, certainly, but even society, has gotten it wrong over the centuries. Quote, but in the view of the Constitution, in the eye of the law, there is in this country no superior dominant ruling class of citizens, period. Now, I'm going to pause there. There obviously is in the UK, right?
Mm-hmm. Yep.
They have a whole house of their parliament for this class of citizens, but I digress. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or of his color when his civil rights, as guaranteed by the supreme law of the land, are invoked. And I'll stop the quote there because then he's going to talk about its use. Actually, no, I'll continue it and then I'll stop the quote after the next sentence. It is therefore to be regretted that this high tribunal, meaning the U.S. Supreme Court, the final expositor of the fundamental law of the land, has reached the conclusion that it is competent for a state to regulate the enjoyment by citizens of their civil rights solely upon the basis of race. And so that's obviously, Mr. Justice John Marshall Harlan, the first one. His grandson would also serve on the same eminent body, but this is a quote. They're quotes from his dissent in Plessy versus Ferguson, 1896. So what he was doing is just giving this magnificent and majestic sweep of the power of our Constitution and laws in this republic. And when somebody, regardless of whether their motives are good or ill, when someone in state government, and certainly the legislature, decides, well, we're going to divide people up and provide this right for these people who look like this and this right over here for these people who look like that, the game is up if that holds. And moreover, during the time frames when such a division held in American society, I mean, those aren't our best years. We didn't achieve our best results in many domains during those time frames. Certainly not in the areas where it applied. And it's strange that and fitting that when we would export that ugliness through our war making, actually. Excuse me, when we would export that ugliness, others would notice and call us out on it. As they should have. So the issue I have with reparations is that irrespective of any claim of justice, to me, it would sound the death knell of the republic. American citizens need to know that when they're dealing with a government, they're not being discriminated against, that they're not having their property taken so that somebody else's grievance can be satisfied, unless everybody's property is being taken to satisfy that grievance, and the particular grievance is not some kind of systemic or class-based grievance apart from like a class action suit. That's the closest we get. And those, in case you know, listeners, or don't know, I guess, they're highly regulated. They're a big pain in the butt to do, because the rule of law in England and here is set up around the principle of a case. So what the judges are supposed to be doing is justice in that particular case for the issues that are actually justiciable, because they recognize, and in our constitutional jurisprudence in the US, we recognize that there are certain types of disputes and certain aspects of disputes that just can't be decided by a court. We accept that. And so here, what we have is someone who is trying to do good and will end up working a bunch of evils that just don't bode well for the American Republic.
So
that's why I don't support it.
Okay, so this is a sea change, because over the course of the last year, between when we last had this conversation and now revisiting it, this is a sea change in Dorollo's thinking around this area, because initially, his initial thought, based on the UK example, which he again brought up today, was that reparations were fine. And my initial objection, and my objection has not changed, was that reparations represented a moral hazard, which we don't ever use those terms anymore, except in economics, but they apply to culture, they apply to government, they even apply to, as Dorollo has said here, the republic and the the framework of the republic. In the course of time between the last conversation we had and now, California's Reparations Task Force has laid out their specifics. They've been reported on in the Los Angeles Times, the NPR, the New York Times, NBC News, CNN, the Politico. You can go search California Reparations Task Force and figure out what it is that they're doing and what it is that they are proposing. The details are out. When we were talking about this last year, it was mere speculation because the task force was meeting. Now the task force has met. The recommendations have been made. The direction has been decided. My position has not changed. Dorollo's position has shifted. Here's something that is interesting. Two things. One, Dorollo talked about exporting our warts to other places. So I recently went to the state of Hawaii on vacation with my family. Never been to Hawaii before. And did the tour of Hawaii and walked around Hawaii, toured some of the, and this is going to be a word, going to be very specific for our conversation here, toward the plantations, the pineapple plantations of Hawaii. The acts that the United States engaged in order to control the pineapple plantations of Hawaii in the 1930s, 40s, and 50s, well within the historical memory of people who are still alive now, could be, a claim could be made that those acts deserve reparations. And I believe a very strong claim could be made. As a matter of fact, when I heard this history and was exposed to this history, because I did not know very much about this history myself, I'll be honest. I had not had time, nor had I had the inclination to look into how we got Hawaii. But when you're there, you have no choice but to look at it. Well, no, I won't say you have no choice. You can remain in a stupor on the beach. You can absolutely do that. And there are many people who do. I decided to look at the history. So I looked at it and I examined it and I heard the people talk about it very passionately, and not just on Oahu, but on several other islands that I visited with my family. And I came to the conclusion that Hawaii has a better argument for reparations from the United States government than African Americans ever possibly could. And the reason
is it
why,
because of the recent nature of the evils?
bingo, it's the recent nature of the evils. It's the time factor that bingo, Dorollo gets the cookie. That's actually it. It's the recentness of it. The people who had the most to gain from reparations as African Americans in this country were people, quite frankly, in my great grandfather's generation, who was a sharecropper, one generation out of slavery. They deserve reparations. The eponymous, Spike Lee's eponymous production company, 40 Acres and a Mule, right?
Correct.
Okay.
Where are they?
Well, those people, those people are dead. And Booker T. Washington would say, you don't need 40 acres and you don't need a mule. You need to go out and get some. Okay.
Well, he's free to give me his and I'll sell to somebody else and make some money. Sounds good.
Right. And that infamous freedman, W.E.B. Du Bois, would be sitting on the California Reparations Task Force. And I think that this represents something that I think we can both talk to very briefly before we turn to something else, because I want to talk to legislative failure. Because one of the things that we're seeing increasingly in our country, and I think the Supreme Court is trying to, at the federal level, is trying to slap around the legislature a little bit, slap around the Congress. And I think the Congress does need to be slapped around. And I'll go into why in just a second. But let me close my point here on reparations. there is a strain in African American history that divides, and we see this with the affirmative action decision, divides elite African Americans or elite Black Americans from everybody else who goes to work.
Mhm.
And everybody else who
Mhm.
goes to work doesn't go to Cornell. They
Okay.
go to, if they go to college at all, they go to like a state school like I went to.
Mhm.
I went to
Mhm.
a state school. I mucked out my fair share of quail pens, and I've done things that I needed to do to make money. Not anything illegal or immoral or fattening, but I've done the things that I need to do to make money. And
What's wrong
I'm
with fattening things to make money? Fattening
well,
sounds good.
those overeating contests, they could be a real for $100. This could be a real
Wow.
challenge. But if you need to make
Yeah.
rent, hey, there you go. So I've done those things. I would think that in this conversation, I probably represent more of the Booker T. Washington strain of African American or Black American direction. And I'm not putting this on Dorollo because I know Dorollo well, and I know Dorollo personally. But Dorollo graduated from Cornell. Let's be real here.
Mhm.
And the W.B. Du Bois of the world graduate from Cornell and Harvard and Stanford and Columbia and these fancy elite, both public and private Ivy League institutions.
Mhm.
And they talk quite a bit, and they make fancy arguments for things like reparations or for social justice that don't mean anything to people like me, quite frankly, because we wind up being the ones that mop the floors at the Ivy League institutions. And none of those W.B. Du Bois progenitors are coming down to help us, not one in the real world. And so this split is reflected in the California Reparations Task Force's recommendations. It's all these attempts to sort of, well, okay, here's a big one. Provide tax relief by allowing descendants who reside in formerly redlined neighborhoods to transfer the assessed value of their primary home to a newly purchased or constructed primary residence. That's one of their suggestions, right? But like, I can live anywhere I want as long as I have the money. I'm not being redlined out of anywhere. If I want to buy $1 million home in Beverly Hills in California, the laws in another part of the world, quote unquote, the world not covered by the California Reparations Task Force, the world of real estate. And by the way, I know this because I am now involved in real estate. In that world, it is illegal to redline, and it has been since the 1970s. So no one alive now who is in their 40s has ever experienced redlining. Sorry, they just haven't.
I disagree. I have talked to people who work in the mortgage industry in this century, and I gave the geography where I did real estate conveyances, and I gave the time frame. I would say no, it still happens. It's just they're craftier. They figure out which of course is in quotation marks and is meant to be nameless and faceless and even colorless. They are just more skilled in going about how to deny opportunities to people who show up and who have the money.
Okay.
You know,
I'm not even going to, I would need more solid proof of life than just they on that.
Okay.
You know,
I can accept that.
The act of redlining in and of itself, when I have people calling me as a real estate agent to test my level of discriminatory behavior, and thus I have to be on call every time I pick up the phone. And by the way, I'm not talking about mortgage companies. That's a different thing. I'm talking about real estate, the people who go out and show the thing on the ground. The penalties and the problems that are involved in that, and the lawsuits. Speaking of lawsuits, it ain't worth your license.
Oh, I agree. I agree with your judgment.
Right. Now, one average real estate agent is engaged in this. my point, and my larger point is this, if the attempt by the California Reparations Task Force, led by the progenitors of W.E.B. Du Bois, the elite thinkers who happen to share my melanin level, if their attempt is to protect me, I wish they would just get out of my way. I wish you would do less to protect me, not more. You're actually making it harder for me to advance, not easier.
Correct. I agree with the get out of my way. Yeah, it's interesting because and that's not the only discriminatory practice in real estate.
No. There are
others.
Many others.
You know,
there are many
others.
others. Yes,
Yeah.
I specifically focused on that one because that's the one that gets brought up quite a bit as being the most infamous one, but that is not
right.
That is
it
not
implicates lenders, and so it's and lenders most often are publicly traded, right?
Right.
Or are a subsidiary of an entity that's publicly traded. So there's a whole lot of society and people's retirement funds that are implicated by their activities. But yes, the example from the bill that interested me more was the one with the improper use of eminent domain. Sorry, improper use of eminent domain, eminent domain. So, proof, that's what litigators like me are forced to deal with. How do we know something is true? Well, you have to get facts in admissible form entered into the record, okay? And so, the advantage of that example is that it directly implicates government action because only the government does eminent domain. And two, the number of people you would need to come forward and confess, yeah, we've been doing this, this was the pattern of behavior, is much smaller. There are arguably tens or hundreds of thousands of Americans who work in the mortgage industry throughout the United States. And I mean mortgages specifically, meaning they work for a lender and they do applications, underwriting, or some other activity involved in lending people money to buy houses or other structures. Whereas eminent domain, that the property department at a city is probably not even going to run 1,000 people. It's too specialized, it's too small. Just need one who can competently testify. Oh yeah, we've been doing this for decades. Let me tell you the stories. Because, the stuff, when it gets written down, when it gets put in an email, yeah, that joker is going to get fired because he was dumb enough to put it in a form where it's now archived. The real talk is talk. And then everybody understands how to look at a set of facts and make a contrary decision based on something that's not in front of them in a way where it's not going to be recorded. Doesn't mean it doesn't happen. Does mean that it's much harder to prove what happened.
Well,
no.
I'm not going to touch on eminent domain for a whole variety of reasons. I will say this. I think that Dorollo's assertions about eminent domain are interesting, and I will leave that at that. I will bracket that and let that commentary just stand. The larger issue here is that bifurcation. And so let's talk a little about the affirmative action decision. The affirmative action decision from the Supreme Court recently. Students for Fair Admissions, Inc. versus the President and Fellows of Harvard College. Okay. Decided June 29th, 2023. This decision that has in effect struck down affirmative action as a method of selection of individuals to elite or any state-funded institution, which in essence means all state-funded institutions. This decision around admission is going to impact the W.E.B. Du Bois of the world much more significantly than it's going to impact the Booker T. Washingtons of the world for a couple of different reasons. One, most state institutions do not use affirmative action as a method of or as a deciding factor in admissions. They haven't for a while now. It's been at least, I think, 20 to 25 years, at least since the University of Michigan Law School went through the ringer with the Supreme Court back like 20 years ago. If you went to college at a state level institution within the last 20 years, and you are African American or any other member of any other minority group, affirmative action did not factor into you getting into that institution. Okay. Which means the Booker T. Washingtons who all go to state level institutions basically can look at this decision and kind of go, okay, that's interesting, and move on. Where I see people getting riled up is at the elite level, the Harvard level, the Stanford level, the Columbia level, the Cornell level. And I see all of these very well educated with Ivy League degrees, W.B. Du Bois types, lamenting the fact of affirmative action going away. And yet, I got to admit, the guys mopping the floors at Columbia don't really care. They're not crying for you, Argentina. Because if you have enough money to even apply to Harvard, why do you need affirmative action? If you are a legacy, and by the way, this is about to be challenged too, I think. If you are a legacy admission, this is about to be challenged. If you are a legacy admission to Cornell or a legacy admission to Harvard, this is about to be challenged too, by the way. Why are you crying? Go to the place where you need to go. Let's talk a little bit. Let's break this down a little bit. Let's take a few minutes to break this down a little bit. What do we think of this? What do you think of the Supreme Court decision? I thought that Justice Thomas's majority opinion, the majority, the support for the majority opinion, which I believe the majority opinion was written by Roberts, if I remember correctly. I think that his support of that opinion, that was an interesting support that Thomas wrote. Again, one in which he admitted to being puzzled by Ms. Ketanji Brown Jackson's approach to the issue, and directly addressed that. And then, of course, her and her dissent, she addressed his concerns as merely a footnote, revealing that there is going to be some, well, let's just revealing that they're not going to be friends. Let's just say that. Again, the Booker T. Washington end of the African-American spectrum and the W.B. Du Bois end of the spectrum are not going to merge gloriously on this court. What do you think of the decision as a lawyer? And what do you think of the merits of this decision? And what do you think of my assertion that it's really only going to impact the elite blacks, and the rest of us who are not elite are going to be just fine?
So you're right. It was Justice Roberts who wrote the majority. He's obviously an excellent writer. Now, personally, I have viewed the issue as being one. Well, let me back up. Let me give it the right kind of context. So I would say certainly throughout the 21st century, that's, up to now, I've just viewed it as a question of time. Sooner or later, it's going to go. Whereas I agree with you that the generation that would have benefited from reparations the most was the generation that actually got manumitted, which technically is not what you said. So that generation, their children after that. And then it's diminishing returns after that, or it's really about something else. Okay. Right. Yep. So, with respect to affirmative action, I understand why people were putting it in place. I think that generally it was mishandled, but I understood its validity. Okay. And yet at the same time, I said, okay, there's a question of time. Sooner or later, too much time will have passed, And the social conditions that arguably made it necessary will not exist anymore. And thus it will not have a justification in a republic where the Constitution and laws and government actions are supposed to be colorblind, are not supposed to take into account ideas of caste or class or any other arbitrary division among citizens who have equal rights and who are entitled to equal protection. So I just thought it was a question of time. Okay. Now, if I'm not mistaken, Justice Powell in his concurrence and not concurrence, in his opinion in the Bakke case from 1980, that's the first case to tackle affirmative action in higher ed. In his decision, he references a time frame. And he basically, you know, if I'm recalling correctly, he intimates that basically, you know, there's a question of time, and beyond it, it's just not going to be viable. And so apparently that's today. You know, apparently that's today. I'm not surprised that, you know, you get a vigorous dissent who frames the issues entirely differently. Fine. But yeah, it's interesting because Bakke, Powell's opinion in Bakke was not really the majority. Okay. But that's the one that came to stand for what Bakke meant. Okay. And so, again, I said before, I think a lot of it was mishandled. Now, okay, let me give one more detail about mishandling it. Okay. If you read General Colin Powell's book, okay, the name is slipping my mind, but towards the end, he talks about politics, and towards the end, he talks about affirmative action and how to use it well. Okay. It's one of the best expositions of it I've ever heard. Okay. And so the idea of going and trying to find qualified people who satisfy other goals, that's what arguably should have happened, and not, well, we're going to take somebody and they're not qualified and we're going to have them come in anyway. The thing that is insulting, and I know Justice Thomas knows because he's written about it in more than one context. The thing that is insulting is the taint, as it were, to our own achievements and our own qualifications that came along with affirmative action. There wouldn't have been a taint if every single candidate had been qualified. A taint only comes about when either they're letting in people for reasons that don't have to do with academic rigor and quality candidates, or someone who's aggrieved is voicing that kind of description of what's going on, and there's no vigorous rebuttal, you know. And so for me, you know, I remember my numbers from Cornell and getting in, and I remember where the average SAT score was, and I remember those statistics, and of course I'm above the average, so I felt fine with it. Then once I got there, I then encountered somebody who doesn't look like me, who had a privileged background in terms of the private schools. He went to the prep schools on the East Coast. You have a picture of what I'm talking about. And I remember being horrified at how he wrote, because he couldn't write. And so in my head, I was like, well, how did you get here? I don't know. I have some ideas, but I don't really know the reason that you're here. But, you know, he was there. There you go. What are you going to do? And so it's a shame in the sense that, well, one, it needed to go. Two, it's a shame in the sense that I just think that, you know, it was largely mishandled. Three, my views on it were informed in part by living in East Asia after undergrad, and having a discussion about this with a PhD level educated Asian American woman who also went to we share an alma mater. Okay, we're both Cornellians. And she talked about the statistics of Asians who get rejected and how highly they score. And the light bulb goes off. And I said, well, wait a minute. So if what she's saying is, it doesn't have to be true. Let's just say it's marginally, no, let's just say it's essentially accurate, okay, or even half true, okay? If you were to then look at a class of students they're not going to look at certainly the way the class that I was part of looked. They didn't look like that, you know. And I'm certain it's changed over time because I've been on campus, for example, and I've seen an increase in certain classes of students. Okay, but if what she was saying is essentially true or even half true, then there's some other selection process that is going on in the background. And as I said, the person who puts it in an email or whatever, that guy gets fired because he's an idiot. The people doing it is talk. And then, as I said before, it's people looking at a set of facts and then looking at an analogous set of facts and making contrary decisions, not based obviously on what the facts say. That arguably is still going on. And so, you know, on the one hand, the overt schemes go out the window, but, you know, it doesn't mean that the counter affirmative action, if you want to call it that, or the anti-affirmative action program in quotation marks, that's not an official program, or it's what should we call it, a project,
I like task force. I like that term.
Right. And so no, I want to call it club, because
Okay.
task force doesn't work, because I can't picture a task force meeting in a country club unless they're busting the country club, because it's like running drugs or something. Whereas the picture I have in mind is guys at a country club and they're just, oh, did your kid get in? Oh yeah. Oh, my kid got waitlisted. Oh, you need to talk to this guy. Right. That happens. That's happening right now as we're talking, you know? And so this decision doesn't stop that. Now,
No.
who benefits? And this will be my last point on it. Who benefits?
Okay. Yeah.
I agree with you that there is a class of African Americans who really don't care about this decision because they don't view it as affecting them and their goals and what they're trying to do. And they don't necessarily all eschew higher education. It's just the way they see themselves and how they go about their actions. They're not dependent on, in any sense, on admission to an elite education institution. Okay, these are people who don't care about Harvard, who don't care where it is, who just they don't care about Harvard. They're trying to go to, you know, I'm just going to pick a school off the top of my head. They're trying to go to Boise State. They don't care about Harvard. They have zero interest in being marooned in Massachusetts, okay, on the ocean. They're trying to be in Idaho, going to Boise State. They don't care about this decision. I get that. My concern is, and again, the decision needed to happen, but it's the impact in terms of how it's sold on minds that are in fourth grade. Okay, you've heard my trope that, and this is with respect to, you know, public education funding, that, you know, how do things change when we realize that the cure for cancer is right now sitting inside of the brain of a fourth grade Black girl who is being educated in Washington, D.C.'s crappy public schools. Now, how do you want to look at the analysis? Because of course the answer is, oh, well, we want to do whatever we can to make sure it gets from her brain into some form where everybody else can use it and the whole world can benefit from what, you know, process she's going to invent. Oh, okay, but since you don't know who she is, you better deal with something on a much more systemic level in that education system in Washington, D.C., or it's going to be stuck in her brain and it's going to stay there. And her brain is going to languish, her life is going to go nowhere. And so people are still going to get cancer and die at numbers that are unacceptable, because the cure couldn't be, you know, couldn't be reduced to reproducible form anyway. So the impact on those fourth graders, okay, what they're being told by the socialist engineers in their schools, that I have a concern about that. And so, as you know, I think it's Oprah, but I think it was Oprah Winfrey, but somebody has been on record in the last 4 decades talking about achievement being the ultimate defense against the nonsense talk that comes about African Americans and achievements, or lack of achievements, so-called, that actual accomplishments, that's what shuts them up. And so I'm mindful of that. I want to see more of that. And but what I want to see is those achievements. And then the talk is directed at those fourth graders so that they understand, look, if you're the best student in this class, you can go wherever you want, period. There's no bar, there's no impediment. Okay. So you should be working on becoming the best in your class, period. That the system is not out to get you. That 80 to 95% of the opposition that you face is self-created. That we go from you didn't do your homework to you can't get a job, and there's a direct link between the two. And there's no random ill-meaning white person involved. You didn't do your homework, you didn't go to class, your grades suck, and now you can't get a job because you don't have basic skills. What do you want? This is nobody's fault but yours. And so reaching them in the right time frame is paramount, but also, with an issue like this, as I said before, this is all marketing, right?
Well,
how is this being marketed?
Well, and I quote, I want to bring you something here. Well, before we close on this and turn the corner, I quote directly from Students for Fair Admissions, Inc. versus President and Fellows of Harvard College. I quote from Justice Thomas's concurring opinion, Part B. I think it's Section 4, Part B. Justice Jackson has a different view. Rather than focusing on individuals as individuals, her dissent focuses on the historical subjugation of Black Americans, invoking statistical racial gaps to argue in favor of defining and categorizing individuals by their race. As she sees things, we are all inexorably trapped in a fundamentally racist society, with the original sin of slavery and the historical subjugation of Black Americans still determining our lives today. The panacea, she counsels, is to unquestioningly accede to the view of elite experts and reallocate society's riches by racial means as necessary to, quote unquote, level the playing field, all as judged by racial metrics. I strongly disagree. First, as stated above, any statistical gaps between the average wealth of Black and white Americans is constitutionally irrelevant. I, of course, agree that our society is not and has never been colorblind. People discriminate against one another for a whole host of reasons, but under the 14th Amendment, the law must disregard all racial distinctions. And then he quotes from Justice Harlan's dissent in Plessy. With the passage of the 14th Amendment, the people of our nation proclaim that the law may not sort citizens based on race. It is this principle that the framers of the 14th Amendment adopted in the wake of the Civil War to fulfill the promise of equality under the law. And it is this principle that has guaranteed a nation of equal citizens, the privileges or immunities of citizenship, and the equal protection of the laws. To now dismiss it as quote unquote two-dimensional flatness, according to Justice Jackson's dissent, is to abide a sacred trust to ensure that our honored dead shall not have died in vain. From Abraham Lincoln. Yet Justice Jackson would replace the second founder's vision with an organizing principle based on race. In fact, on her view, almost all of life's outcomes may be unhesitatingly ascribed to race. This is so, she writes, because of statistical disparities among different racial groups. Even if some whites have a lower household net worth than some Blacks, what matters to Justice Jackson is that the average white household has more wealth than the average Black household. This lore is not and has never been true. Even in the segregated South, where I, Justice Thomas, grew up, individuals were not the sum of their skin color. Then as now, not all disparities are based on race. Not all people are racist, and not all differences between individuals are ascribable to race. But simply, quote, the fate of abstract categories of wealth statistics is not the same as the fate of a given set of flesh and blood human beings, close quote. Thomas Sowell, Wealth, Poverty, and Politics, 2016. Worse still, continuing on from Justice Justice Thomas. Worse still, Justice Jackson uses her broad observations about statistical relationships between race and select measures of health, wealth, and well-being to label all Blacks as victims. Her desire to do so is unfathomable to me. I cannot deny the great accomplishments of Black Americans, including those who succeeded despite long odds. nor do Justice Jackson's statistics regarding correlation between levels of health, wealth, and well-being between selected groups prove anything. Of course, none of those statistics are capable of drawing a direct causal link between race, rather than socioeconomic status or any other factor, and individual outcomes. So Justice Jackson supplies the link herself: the legacy of slavery and the nature of inherited wealth. Close quote. You can go and read that if you want from the decision directly. This is really the crux, isn't it? This is the crux of what I was talking about. The person that you described who wants to go to Boise State College doesn't view the world in the way that Justice Jackson views the world. They view the world closer to the way that Justice Thomas views the world. I view the world closer to the way that Justice Thomas views the world. But there are people writing right now in Black culture on Twitter who view the world the way Justice Jackson does, and they are going to do their damnedest to get into admission offices across the country to make sure that while Clarence Thomas and the court, to paraphrase from Andrew Jackson, they've made their ruling, good luck enforcing it. How do we... Is this just something we have to live with as African Americans in this country? Is this just a separation we just have to live with between the elites and the rest of us? Or is this something that can be pulled together? Because, you know, all of us, I won't say all of us, many other minority groups will ask African Americans, where's your leadership, right? Recalling the halcyon days of Martin Luther King Jr. Except the problem is we all live in the backwash of Al Sharpton. You know, and so, you know, and Sharpton's getting ready to go himself. Like, he is not long for this planet. His days can be measured out probably in coffee spoons. Who leads Black people? Who unites the W.B. Du Bois and the Booker T. Washingtons? I mean, we covered this a little bit when we talked about Up From Slavery and Souls of Black Folk with Dorollo back in February. Who unites us? Or is it all just going to be disparate for the next 25, 30, 40, 50, 100 years, while that little Black girl and her progeny still continue to suffer in schools where the administrative spending per student is 80% of what we actually give the student? And that little girl who may have a cure for cancer inside of her head is instead being trained and being educated to go stand on the corner and to sell drugs. And not just in Washington, D.C., in Chicago, where the 8th graders can't read, in L.A., where Hispanic gangs and Black gangs kill each other, in New York, where the spending per student is the highest per capita in the country. And yet African-American students, again, can't read. And yet everybody sort of goes, that's okay, that's fine. The administrators make money. The school districts make money, the cities make money.
And who loses?
And the children lose. And Justice Jackson types only look at this through the lens of race. That's the only lens they can see it through. If you confront them with the money, they dismiss that. They say it's, well, just another form of systemic slavery. Meanwhile, I look at the money and I look at the racism and I look at whatever and I go, it's not racism. It's lazy bureaucrats. It's venal and self-serving policies. How are we going to pull this together? Or is it going to be a bootstrap thing, just like in Asian cultures? Is it going to be a bootstrap thing where we have to go family to family to family in the African-American community for the next 120 years and just bootstrap?
Well, you know, it's interesting because how individual family units will actually advance economically, to me, is separate from who will lead African Americans. What I find interesting is if you compare us to WASPs, to Chinese Americans, who speaks for them? It seems like as time goes on in America, everybody kind of just disintegrates into the great fabric of this great nation. And so the group identities that we come into the country with, whether forcibly or voluntarily come into the country with, over time seem to dissipate. they seem to weaken in favor of the new identity of, the American citizen. So it's interesting because if that trend actually exists, because this is me, thinking out loud. So let's assume for the argument that trend exists. It means that as time goes on, there will be less and less demagogues trying to get in front of a screen, right, on a screen, talking at us and telling us how to think, how to feel, whom to vote for, certainly, and how to act in other ways. I don't necessarily think that that's bad. Okay. It's interesting though when you think about it. Who speaks for WASPs? Who speaks for Chinese Americans? No idea. And I don't even know if they're looking. Are they looking for a spokesman, or are they focused on their platoon of their family, saying, how do we make this thing go forward? How do we live according to our values? Worship God as we see fit, and be good citizens in this our nation. Because it's as much their nation as ours. I found in research for the last podcast, I found this speech by that eminent fellow Rochesterian, Frederick Douglass. That, of course, is my hometown. I was born and raised there, and he adopted my hometown as his hometown more than a century and a quarter before I was born. But anyway, wait, is that math right? Yeah, at least more than a century. It's possible more than a century and a quarter before I was born. But anyway, he did a speech against the type of agitation and legislative work that led to the Chinese Exclusion Act of 1883.
Okay.
And he talked about the benefits of having Asian immigration and the benefits of having other peoples as part of this great multiracial experiment in a unified nation. And I thought it was beautiful. I was surprised to see it. I thought it was beautiful, and I think it's relevant to what we're discussing here, where it's just like we are swiftly moving towards the colorblind society. At the same time, we're swiftly moving toward a society that has no normative structure, and where the loudest voice carries the day, and words don't have meanings. And so anyone is entitled to anything they want and claim, and then the government will pay for it. We had a president who, as a candidate, said, I'll build the wall and Mexico will pay for it, right? And now it's, I have these rights and the government will pay for it. And it's just like that's fatal. That's not going to last. So we need a course correction, obviously. We have the framework and the laws, and frankly, the culture that allows for widespread amounts of dissidence and dissent and different behavior. We don't need to resort to the word games that people do. And I remember from the late 90s and the trials of President William Jefferson Clinton, and people talking about, well, it all depends on what the definition of is. And I remember a deposition of, one of the most famous Americans who's ever lived, Bill Gates, in which it took him an inordinate amount of time to answer one question. And I presume it was because his brilliant brain was analyzing all the permutations and all the possibilities and trying to get around having to, admit to something. It was really good lawyering on the other part. But I remember that. I remember when those were the word games, because we all knew what words meant. And now, you fast forward 20 years and here we are, and it's just the 25 years, and here we are, we're just unmoored, someone cut the anchor chain and now we're just drifting. And so the irony is, against that background of drift, you have a decision where in its words and language, it's predicated on what should be bedrock principles about how American society and governance is supposed to function. It's a colorblind society, and certainly the laws of the Constitution are colorblind. So this is how you're going to be treated. And so if you're the best student, you should not have to worry about if you're going to get in or not. You'll get in. You know, if you're the 50th best student, well, maybe you should have studied a little harder for the last couple of years. Some places will let you in and some places won't. Okay. That's generally going to be the outcome over time. This decision, certainly the concurrence of Justice Thomas, is like moored. It's rooted in those principles and facts and assertions about what it means, what America means, and what it means to be an American. And it's still such a beautiful thing. So I hope the fight continues, because you know, it's a country that does so much good and has helped so many people. And I've lived all over the world, so I've seen alternatives. I've lived under alternative forms of government. And more than one alternative form of government. And I've traveled in countries where it's just chaos. And I don't want to see our nation become like that. And we don't have to, but you know, somebody's got to talk back to the talking heads, talking nonsense, talking about, well, this is statistically this, that, the other thing. We have a common law principle that says that those jurists are doing justice in individual cases. So bringing in statistics as they apply to an individual case is just really difficult. You bring in facts that actually exist with respect to that dispute, and then you let the fact finder find facts and the judge render his or her decision. And that system works.
I think, as we round the corner here on our podcast today, a wide range of conversation covered many things from, you know, the UK laws around blasphemy all the way to equal protection and normative frameworks, and even the drift of our culture that many of us have been experiencing and or feeling over the course of, I would say, the last 10 to 15 years. As we round the corner on this conversation, I would say this. I think that both of the Supreme Court decisions, the first one around the website that went against the state of Colorado, and then this one that we have been discussing that went against Harvard University. I think that these are two signs, and I'm going to quote, as I've been quoting this month, from Gandalf in The Two Towers, when he comes back after he falls as he's fighting the Balrog into the pit, and the famous scene in the movie. And by the way, we'll be covering Lord of the Rings in September, so show up for that. But as he fell into the pit, he died, right? Or at least the members of the Fellowship, including Frodo Baggins, saw him die. And at one of the penultimate moments in The Two Towers, when all is lost between the forces of Saruman and the forces of Mordor, when the good guys look like it's all done for them, a white flash occurs, and Gandalf, now no longer the gray, but Gandalf the white, steps out of the light and says, "Behold, I come back to you now at the turn of the tide." I think that both of these decisions are turn of the tide moments. And I think that they will be seen as such. I think the drift is being arrested in ways both large and small. But I do not think that it is being arrested in ways that resemble the way drift was arrested in the past, not through appeals to tradition or religion or through a common culture or a common language. But instead, I think the drift is being arrested by individual people doing individual things in individual families. I think this drift is being arrested through bootstrapping across our culture. And this is not, again, me just looking at this from my own bubble or me being a pie in the sky. Dorollo will tell you I'm not a pie in the sky guy. And I'm probably infinitely more pessimistic than even he is. However, I do fundamentally believe that something has shifted in the Republic. I can feel it in this zeitgeist. And I've said that this month of July, this month of freedom that followed on a muted month of pride. And now we are going to go into the rest of the summer, the long downhill slide into fall. And I think a collective decision has been made in the Republic, and the Supreme Court decisions reflect this decision. They are the lagging indicators of something that was decided probably a couple of years ago coming out of COVID. And I think the decision has been made that we will still be a republic. We will still be a place of law. We will still be a place where we will attempt to move towards a more perfect union, and where we will attempt to be colorblind, because the alternative, which we all saw during the summer of 2020, is still intolerable to our disposition as Americans in this republic. And by the way, not the Americans that you see in Washington, D.C. or in your state capital. They're lagging indicators too. It's going to be a couple more election cycles before we start getting politicians who reflect the change. I think it is. So it won't come in 2024, and it won't even come in 2026. But I think by 2028, 2030, we'll start getting the post-COVID politicians. And they're not going to look at the world the same way that pre-COVID politicians did. They're not going to be cut from the same cloth. You're going to have a lot more of folks like, well, I think that you are going to have folks who, and I can't believe I'm about to say this, who initially at least resemble more like Patrick Henry, Marjorie Taylor Greene, or Lauren Bonner. They resemble much more of the Patrick Henry strain of the Republic. But I think you're going to have that tempered over the course of the next few election cycles. And I do think by 2030 or so, if I am correct on the cultural zeitgeist pieces, I think you're going to have a more stable republic. A republic where a new anchor will be dropped. But that does not mean that we should let our foot off the gas, and it does not mean that we should stop moving towards that more stable republic, and it does not mean that we should not stop pressing against these forces that would seek to keep us adrift.
Yep.
And this is what leaders do, right, Dorollo? They push again. They recognize the forces that seek to push them adrift, and they say, no.
Yep. They stand athwart the, what was it? Athwart the current of history, yelling stop.
That's right. That old patrician, William F. Buckley.
Yep. Yes, indeed.
That old New England patrician.
Born in Mexico. I think his first language was Spanish. Try trotting that out and see what kind of response that gets.
Oh, he was best friends with Jack Kerouac.
Believable. Yep.
And was roommates with him at Yale.
Dang. College roommates. Nothing like him.
Nothing like him. With that,
at Yale or otherwise.
Yeah, Yale or Boise State College or even Ranger Technical School, wherever it is you may be happening to go to.
Yep.
With that, I'd like to thank Dorollo for coming on the podcast today. I think this, like I said, this was a wide range of conversation. And while not specifically book oriented, I think it did do a lot to pull together various threads that we've been exploring this July on the podcast, and honestly been poking around a little bit at for the last half a year. This episode represents a pivot point, and now we're going to get into other things. We're going to be talking about other books coming up towards the back end of the year, including Buried My Heart and Wounded Me. We're going to get into the struggles of Native Americans in our culture. We're also going to be looking at, well, the nature of mere Christendom as related in fantasy, as I already talked about, is through Tolkien's The Lord of the Rings and, of course, The Hobbit. We are going to read, in addition, Ender's Game by Orson Scott Card, a book that is on the recommended reading list for the United States Marine Corps Officers Training School. Yeah, put that one in your pipe and smoke it. And then we'll close out the end of the year by focusing on Christmas via the lens of Willa Cather. And of course, our good friend of the show, or our good friend of the show, Charles Dickens. And in between that, we'll talk about what I think is the great American novel, Moby Dick. the first truly great American novel, Moby Dick. And we will also, in November, bring Libby Younger back, and she and I will break down the penultimate work that I think Ernest Hemingway probably should have won a Pulitzer Prize for, The Sun Also Rises. So that's just a preview of coming attractions. Once again, I'd like to thank Dorollo for coming on the podcast. Do you have anything you want to promote for the listeners today? Any places where we can find you? You got any books coming out? I know you're a bit of a scribbler yourself. You got any books coming out? Anything we should be looking for around the corner or around the horizon from you?
Not soon, but of course I promote the U.S. Constitution and I promote the Bible. Read them both. You've been warned.
And with that, we're out. Thank you for listening and subscribing to the Leadership Lessons from the Great Books podcast. If you're listening to this on any of the major podcast players like iTunes, Google Podcasts, or Spotify, please go ahead and leave us a 5-star review and write a little bit in there. A couple of sentences is good enough. That actually helps us game those algorithms that I was just maybe addressing. And, of course, it helps us grow the show. Tell all your family, tell all your friends, and tell the leaders in your life that you know that need to be listening to this show, that this show exists. By the way, if you want to get started on the leadership path yourself, or you know some people who need to go on the leadership path, HSCT Publishing, the home company of Leadership Toolbox and Leadership Lessons from the Great Books podcast, can help you and your team do that. So check out our training webinars, coaching services, and more at leadershiptoolbox.us. We are remote, we're live, we're in person, we're on video, and we've got leadership development solutions for your civic group, nonprofit staff, public sector staff, or even your private sector leaders. And of course, you're going to want to check out our video-based subscription service at leadingkeys.com. That's leadingkeys.com for leadership development on demand. You don't like videos, you don't like training, but you really like the podcast? Well, I would also recommend reading a book. Matter of fact, I'd recommend reading my most recent book, 12 Rules for Leaders, The Foundation of Intentional Leadership. You can get that in paperback, hardcover, or as an ebook on Amazon, Barnes & Noble, Kobo, Ingram Spark, and any other place that you order books online. Finally, of course, we're on YouTube just like everybody else is. We'd love to have you help us grow the YouTube channel, so like and subscribe to the video version of this podcast on the HSCT Publishing channel on YouTube. Just search for HSCT Publishing, or you can search for Leadership Toolbox and hit the subscribe button. Subscribing helps us grow the show. As it does with the audio, just is the same with the video. All right, that's it for me.